Good afternoon. The Subcommittee on the Federal Workforce, U.S. Postal Service, and the Census will come to order.
Officials. The WPEA also expanded OSC's authority to file amicus curiae briefs in cases related to Federal whistleblower retaliation. OSC has filed 3 amicus briefs in Federal courts, including one just this past month, and we are currently in discussions with the Department of Justice about OSC filing an amicus brief in the U.S. Supreme Court later this month in the MacLean v. Department of Homeland Security matter. This would follow the amicus brief that we filed in Mr. MacLean's case with the MSPB in August 2011.
Thank you very much. Mr. MacLean, look forward to hearing your story.
Thank you, Mr. Chairman, and Ranking Member Lynch and Ranking Member Cummings. I was in the first class of 35 Air Marshals to graduate after the 9/11 attacks of '01. In '03, a perfect storm hit. All marshals were called in for emergency training. Al-Qaeda hijackers would exploit U.S. Department of State visa and checkpoint screening loopholes in order to sneak weapons onto long-haul flights, kill crews, and crash their jets. Briefers were specific to major U.S. East Coast cities and European capitals. 2 days later, TSA blasted out an unmarked text message to all marshals' unsecured cell phones. Cancel all hotel reservations to avoid all cancellation fees. Flights for 4 hours or longer wouldn't have had marshals for 2 months until TSA got its new fiscal year funds. Marshals around the country told me that they got the same text. We thought it was a mistake, given the alert and a very specific law that 9/11 type flights must be covered. I called a supervisor who confirmed TSA formed a global plan because it was broke. I called 3 IG offices until I spoke to an agent detailed from FEMA. He just warned me about risking my career. Since the text was not specific, it was not marked nor secured, I called a reporter covering TSA's dangerous rules. He verified with marshals across the country and was in contact with Congress. The story went on the web. Hours later, most press had coverage of outraged bipartisan members of Congress, including Hal Rogers, the Republican chairman with the oversight of the TSA. After first denying it, TSA said it made a mistake and canceled its plan before ever taking effect. The IG said the TSA blew cash on executive bonuses. Weeks later, I co-founded the Air Marshal chapter of the Federal Law Enforcement Officers Association. FLEOA, it's not a union, but a collective voice to work with Congress and agency officials to better safety and security. The Air Marshal Service Director asked the IG to investigate me and my FLEO Air Marshal Board for complaining about hazardous policies. He called us organizational terrorists. For 2 years, we worked with Chairman Jim Sensenbrenner's Judiciary Committee. In '06, he issued a 147-page report about the Air Marshal's dangerous policies and retaliation against us FLEOA representatives. None of this was considered retaliatory because the director and his executive who fired me, Frank Donzani, later testified that they were all at one time FLEOA members. Mr. Donzani told me I was under suspicion for disclosing unclassified sensitive security information, or SSI. Internal Affairs ordered me to divulge all media I was a source for. I admitted to everything, as it was all unclassified at the time, and everyone agreed with me, Congress, bipartisan. But a decade later, I've been second-guessed in hundreds of briefs and hearings and depositions. Dumbfounded for 19 weeks, TSA finally concocted its single charge to fire me. The text message it chose not to send to our $22 million encrypted smartphone system was now SSI. TSA forced its SSI chief in charge when I made my disclosure not to show up for his ordered deposition and replaced him with an attorney who was with the Postal Service when I made my disclosure. TSA was a little nervous. Its attorneys interrupted him 252 times during his deposition. This was the TSA's expert on SSI, who didn't come to the TSA long after I made my disclosure. Mr. Donzani was the only witness allowed in my hearing 3 years later. Everyone else was denied. Despite unbelievable excuse why he didn't have the authority to ground me for almost 5 months, The fact that he was permanently removed from all supervisory duties just weeks after my hearing, Mr. Donzani's credibility was never scrutinized. Despite a precedential decision, a unanimous Ninth Circuit Court of Appeals panel ordered that TSA's 03 program's lack of clarity must be considered. But all of the TSA's SSI experts were blocked from my hearing. Last year, in another precedential decision, the Court of Appeals for the Federal Circuit unanimously ruled I did not violate any laws and ordered a new hearing to determine if I had a reasonable belief of any wrongdoing. The government en banc appealed that decision to every Federal Circuit judge. It was denied unanimously. Finally, Mr. Chairman and Ranking Member Lynch, TSA took my testimony out of context to cancel the Ninth Circuit's unprecedented, it was unanimous good faith belief order. It quoted me as saying that it didn't matter to me if I disclosed SSI to the public. But what the transcript reveals is that I stated that it did not matter if I disclosed SSI to my supervisor. It was a perfect cut and paste job. With that, the government now argues in its current appeal to the Supreme Court of the United States that I, quote, intentionally release sensitive security information, unquote. My oral arguments before the Supreme Court are November 4th. I look forward to answering your questions. Sorry for going over time.
You didn't do too badly.
This November, the Supreme Court will hear its first WPA case, Whistleblower Protection Act case, since the law was enacted. At stake are the two most basic significant premises for this law. First, that only Congress can restrict public whistleblowing disclosures, not the agencies who allegedly engaged in fraud, waste, abuse, illegality, or activities threatening the public. Otherwise, wrongdoers would have the right to gag whistleblowers exposing their own misconduct. Second, when Congress restricts public whistleblowing disclosures, it must do so with specificity. Otherwise, employees will have to guess whether they have legal rights when they serve the public's right to know, and uncertainty creates an inherent chilling effect. An adverse ruling would cancel everything that we had accomplished in the Whistleblower Protection Enhancement Act. We believe a congressional friend of the court brief from Mr. Cummings, as well as others at the Federal Circuit, made a major difference in the results. And we're recruiting participants for a congressional friend of the court brief to the Supreme Court.
Mr. MacLean, I want to thank you for the work that you've done to further, if you will, our awareness. The fact is that I look forward to your case being fully adjudicated, and I think, in fact, that's part of what we on the dais want to make sure is made available, is access to whistleblowers in a appropriate venue of their choosing. And then let's see ultimately when they trickle up to the Supreme Court how they're decided.
Okay. Mr. MacLean.
Throughout my case, the TSA just thumbed its nose at MSPB orders and Federal Circuit Court orders. So the agencies are allowed to get away with what they do because I think the MSPB is too weak to uphold the orders, and they just go ahead and ignore them, such as switching out witnesses and ignoring deposition orders.
So some teeth in dealing with folks within agencies who disregard the whistleblower protection might be something you would suggest. Is that what I don't want to put words in your mouth.
It's hard to say because almost there was just never any accountability when the final decisions came from the full board and from and I think they're overwhelmed with a lot of caseload. It's good that this is opened up to multiple circuits because I think the Federal Circuit was overloaded with this, and now it's good that it's been spread around. So now they can spend more time. to take a look at this.
Thank you very much, Mr. MacLean.
I would advise people that your whole life is going to change. It doesn't matter what you believed, what was doing right at the time. Years down the road, everything that you said and done is going to be highly scrutinized. A lot of your friends at work are never going to talk to you again. You could lose your job. It's a huge, huge risk. Prepare for the absolute worst.
Would you do it again?
Absolutely. I was a law enforcement officer. You paid me 3 times, 4 times more than your average Federal worker to make split decisions in one of the most dangerous areas to enforce the law. So it was my duty. It was my oath to do what I had to do. And at the time, I believed I was doing everything to protect the public. So absolutely, I took that law enforcement oath, so I would do it again and again. There's better people than me have given up worse, given up more.
Thank you very much.
The risk that Mr. MacLean talked about, and I hate hearing that you take your life in your hands, and maybe we haven't really drilled down on Mr. MacLean's case, but I'll do that now. You served as an Air Marshal back in 2003, and what I understand is in August 2003, TSA proposed a change in policy to cancel all Air Marshal coverage on long-distance flights for that time period. And it coincided with a period of high risk on the airlines, long-distance airlines, from Al-Qaeda. Isn't that correct?
Yes, sir.
And you came forward after you received your notice, which was non-classified at the time, and you complained about it. And you also, as you described earlier in your testimony, you went to the press, and they confirmed it with other Air Marshals. And instead of being rewarded for your diligence, of course, TSA had to change their policy. You were fired in, what, 2006?
Yes, sir.
And the excuse they used was that they had gone retroactively and in 2006 changed their classification of your text messages that you received to classified. And so you were in a sensitive position. Is that what their argument is, basically?
They retroactively designated my disclosure with an agency-regulated, unclassified marking called sensitive security information, years after the fact.
Right. And so you were fired for that.
Yes, sir.
Tell me and tell this committee about the difficulty you've had in getting employment as an Air Marshal or other employment since that job action.
I applied for almost a dozen police agencies in Southern California, and none of them even came forward and said, we don't want to hire you because you got fired from the TSA. I simply got, thanks for applying. You weren't the most qualified. Maybe try again in the future. I only had a high school diploma, didn't have a college degree, so it was very difficult for me. And most of the jobs I've been from jumping job to job with commission-only door-to-door sales jobs. It's about the only thing I could find. So yeah, I was pretty much blackballed from being a veteran, Air Force veteran, a Border Patrol agent. The man who fired me said I had an impeccable, perfect record. It didn't matter. I still couldn't get a job as a cop again.
What exactly were you told about how your career may be harmed if you didn't remain silent? Were there any warnings given to you about what you were doing coming forward?
After the fourth proper channel that I went through, which was finally a special agent with the Inspector General, he simply said, the agency went broke. This happens. There's nothing you can do. There's nothing we can do. You don't want to cut your career short over making a big deal about this. and that was at the final time I was advised not to go further.
Well, I think the circumstances that you find yourself in is a disgrace to us as federal employers, both yourself and Dr. Van Boven. I think your example is extremely instructive to us going forward in trying to devise a policy where employees like yourself will be protected during this process, and that I think you prevented a dangerous situation from being put upon the public, the flying public, and it's a disgrace that you're being punished for that. So, thank you for your testimony. As I said, I just wanted to spend a little time on your case and amplify it a little bit. Hopefully, it will help you going forward.
Thank you, sir.
Thank you.
I'd like to thank everybody on our witness, especially our whistleblowers. I'm going to echo what Mr. Lynch said, that it is a disgrace, and I hope you take away from this, the members of this subcommittee, I think unanimously are committed to making the situation better, and we're going to keep working on it. Again, thank you all for your testimony. The subcommittee stands adjourned.